speaker as well, so just bear with me. We're here today to talk about the Florida market. Florida by sales is the third largest cannabis market, only behind Colorado and California. With last year, I think we did about 1.2 to 1.3 billion dollars of sales. We're by far the biggest medical market. Our population size is over 20 million. Our tourist population is almost 150 million. So statistically, Florida is very well poised to be an extremely large player in the future cannabis market. And with some of the stuff that has been occurring recently, especially with the Florida Grown case, which we'll be talking about, there should be some opportunities to potentially get involved. So today we're gonna kind of talk about what to expect next here in Florida, and hopefully provide you guys with some advice as far as how you guys could get involved. So a few housekeeping matters. Like I've mentioned earlier, if you have any questions, just drop them in the chat box or the Q&A box. We'll make sure we get to them when we get the chance. And that's pretty much it. So we're going to get started and get rocking. So without further ado, what I'm going to do is I'm going to let our speakers quickly introduce themselves and talk a little bit about their position within the cannabis industry and what they do for their clients. So I'll start with you, Jeff, if you could kick it off.
Sure. Hey, thank you, Dustin. Jeff Sharkey here. I'm based in Tallahassee and appreciate the opportunity to participate today. We'll all miss Paula, I'm sure. And of course, then she can buy lunch next time around. As I mentioned, I'm in Tallahassee. We have a government relations business consulting firm, have been in the business for 25 years. We have a wide variety of clients from SpaceX to Tesla to a lot of innovative companies. But with respect to the medical marijuana market, when the first piece of legislation, 2014, was introduced to the legislature here, we got involved in on the legislative side, working on that particular piece of legislation. And then because of all of the various interests coming into Florida, interested in getting involved in that, we created the Medical Marijuana Business Association of Florida in 2014. That organization continues to exist, and that's designed to provide some rational policy direction, best practices, information to both the existing licensees and to others interested in tracking what's going on in the industry. So we've been involved in both the policy and the legislative side of this for some time. We worked with a number of applicants in the 2015 application for licenses successfully. And of course, over the last 3 years, waiting on the final ruling and the litigation on the Florida Grown case, and have discussed the opportunity, what's required for the opportunity to apply for an MMTC license really for over the last 3 years. So now with that ruling resolved, really it's game time in Florida. We've had conversations with the governor's office and the Office of OMMU about their timelines and their focus and how they plan to roll this out. So we can get into some of that later.
Absolutely. Thank you for that, Jeff. Eric, you're up.
Absolutely. Thanks, Dustin, for having me. And Jeff, good to see you as well. My name is Erik Range. I serve as the board chair for Minorities for Medical Marijuana. I've also worn a number of other hats in this space as well. I got started back in this space back in 2015 with my company Art 420 and got into the advocacy role and helping to shape things back in 2017. In particular, as it pertains to the diversity language that is a part of the statute, as well as getting FAMU, one of our historically Black colleges or universities, involved with hemp research and getting the $10 for every medical marijuana card to do outreach and research. So I've been around the space from an advocacy standpoint. Our organization now exists. We started here in Florida and we're headquartered in the Orlando area, but we now have 27 chapters around the country, a chapter in Toronto, one in Jamaica, and now one in London, and really are participating in a variety of different ways, from public policy to community engagement and education and business development, helping to get minorities into the space and just create an overall diverse supply chain for the cannabis industry. So I'm just super excited, obviously, to see Florida move forward. I am a native Floridian. I got into this industry and with an interest in seeing Florida, really grow, and it's taken some time, but I'm happy to see us, begin to move forward. So happy to have the conversation today.
Absolutely, and thank you both for being here. I'll give my quick introduction. I'm an attorney. I'm also a CPA. I'm the founding partner of Mr. Cannabis Law, which is a Florida-based full-service law firm exclusively focused on the cannabis and psychedelic space. I'm also the managing principal of Iter Investments, which is a venture capital firm deploying capital within the psychedelic biotech space. And I have had the pleasure of working with both Erik and Jeff in various capacities, and they've both done tremendous amount of stuff for this industry. And I think, all of us have been kind of just waiting for new licenses to open up. So I think we're all very excited for potentially these applications to open up and hopefully some licenses to be granted. So I'll kind of kick it off with just talking about how we got here. So in 2014, we had a statute that got passed. It was basically low THC cannabis. And in 2015, they had an application process. Through that application process, they basically licensed 5 parties. Those parties were vertically integrated companies, so they had to grow, process, dispense, and deliver. Subsequent to that, there were lawsuits that were filed against the state and against the department. Those lawsuits basically resulted in additional licenses being issued that got it up to 14 licenses. And then later on, the one-pointers is what they're called. 8 one-pointers basically got licenses as well. So where we sit today is we have 22 licenses, and what happened during all of that, we had in 2016 a constitutional amendment that basically through the Constitution made medical marijuana legal. And so then there was a statute and rules that were put forth pursuant to that. And so as we sit here today, we have a legal framework that is fully vertically integrated. So once again, you have to grow, process, dispense, and deliver. And originally there was a cap on the amount of dispensaries you could open up, but that has actually expired as of April 2020. So these 22 MMTCs that own these licenses, they could not only grow, process, dispense, and deliver, which is very unique when comparing it to other states, but they also essentially have no cap on the amount of facilities they can open up, which really makes them very well situated to capitalize on building out an enormous footprint for once recreational actually becomes available. So since 2015, there's been no license, no application process really. The 22 licenses that were issued were really pursuant to that 2015 licensing. Many of them, like I mentioned, were through litigation, but they were through that 2015 application process. And what's really held this up is this Flora-grown case. And the Flora-grown case essentially was challenging the whole vertically integrated structure as well as the cap. And the lower courts and the appellate courts both said that the vertical integration was contrary to our Florida Constitution. However, as of recently, the Florida Supreme Court essentially reversed and remanded those rulings. So as we sit here today, vertical integration is constitutional according to our Florida Supreme Court. So we're expecting the Florida Department of Health to kind of move forward with some licensing. And I think that's a good time for me to kind of pause and send it over to Jeff Sharkey, who's out in our state capital in Tallahassee, to really tell us what the time frame seems to look like as far as new licenses being issued.
Well, thank you, Dustin. As you pointed out there, for those of you who are listening, after that 2017 law that was passed allowed for 10 licenses but it also allowed for an additional 4 licenses for every 100,000 qualified eligible patients that ended up in the patient registry. So obviously it's been 2 years. Those number of patient registry numbers have gone up. So today, actually, we're looking at 19 new MMTC licenses available. One of those is set aside for a what they call a black farmer, a Pigford litigant, which we can go into, Eric can go into. We spent a lot of time on that. So again, we have 22 existing licenses. We're really talking about doubling almost the size of the industry. They are vertically integrated. So my conversations with the regulator over the last 3 weeks, once that ruling from the Supreme Court was decided, and Flora Grown, Dustin, as you pointed out, did not appeal it. So frankly, that case is resolved. They're going to move forward. They've been contemplating moving, the Department of Health has been contemplating moving forward, obviously for months and months and months, whether it was going to be vertically integrated or decoupled, depending on how the court ruled. So they have, they've been developing their rule. For those of you who track this stuff, the application for the MMTC license is part of the overall rule that the department has to promulgate for the entire program. There was a rule that came out of the 2017 law, 2018. That rule, for those of you who are tracking this, included an application template, which I'm sure many of you have seen, kind of an evaluation rubric that they were going to use to score it. That was an emergency rule, and it expired in March. So that rule is no longer in effect. The Florida legislature has granted the department emergency rulemaking power through the budget this year. So the department can move forward rather quickly using emergency rulemaking powers, or somewhat slower using their regular rulemaking authority. My conversations with the regulator are that they are going to move forward first with the black farmer license, the MMTC license. They're developing that rule, that black farmer application framework will be very similar to the other 18. But as you probably know, since that emergency rule that just expired has been around for 2 years, in that 2 years we've had a number of changes to the industry. We've allowed for smokable flower when Governor DeSantis came in. There's a whole new edible rule requirement, and there are other factors. So the Department of Health is developing and finalizing their rule now, again, so which will add some things to that application set of requirements. So my understanding, and the department did not have a really clear timeline, but knowing that they're going to roll the black farmer license out first, see if it gets challenged. They anticipate there'll be challenges. Under the emergency rulemaking authority, they can move very quickly. Any challenge gets resolved in a month, 33, 34 days. So while that's moving forward, you will see what kind of challenges there are to the core piece of the rule. And then once that rule is resolved and any challenges are resolved and the black farmers can apply for the license that once set aside, there's a good possibility that the department will then roll out the rule for the other 18. In my conversations, they know a lot of people have been waiting. They think this is going to be very competitive. They anticipate challenges. They would like to get this moving. I mean, I can tell you that they were very clear in saying that there is either from the governor's office or the Department of Health, there is no intent to hold this up. I mean, there's always some sense that maybe the existing licensees would like to slow this down. They've been very clear saying this is going to move forward as quickly as we possibly can. So in terms of, I mean, I'll give you a ballpark time frame. We counsel people who are interested and our clients. I think the black farmer license application process will be submitted within 4 to 5 months. That includes resolving some challenges possibly, at which point I think in parallel towards the end of that process, the regular rulemaking the regular applications will be moving forward. So there'll be an entire rulemaking process, for those other 18 licenses. So we, by the end of the year, we should have, I know that sounds like a long time from now, but at the end of the year, we should have a really clear indication of what that rule looks like, what the application is going to look like, and what the kind of the final time frame is. None of us can anticipate, none of us can speculate on the holdup regarding challenges. That always takes a little bit of time up here in Tallahassee, but what they have indicated to me is that they're moving forward. They're going to push this forward, and they feel comfortable that the rule they'll roll out here will be as tight as possible. So let me stop there and
Awesome. Yeah, thank you, Jeff. And it seems like the department, they've been, had so many lawsuits in the state. So it seems like, obviously they want to get these licenses and these applications out, but they're also being very careful about how they roll it out and make sure they go through the proper rulemaking process. And so, we're hopeful that they could get this done relatively quickly. Erik, I'm going to kick it over to you. I mean, I know you and I, we've worked on social equity applications in other states. We did a bunch of stuff in Illinois, and all these states right now that are coming online, whether it's New York, New Jersey, Connecticut, they're all kind of making social equity a key component of that legislation. So I guess, could you just give us like a little overview of how diversity and social equity plays a part within our Florida statute, and then also kind of, I guess, just roll that into, a little bit more background on what's going on with this Pigford license.
Yeah, absolutely. I think it's important to note that when we got this language into the bill, years ago, back in 2016, 2017, it was being debated and finalized. Florida at the time was seen as a leader when it came to this issue of diversity in the cannabis industry, because at the time, social equity as a concept, if you will, of awarding licenses to those who had been, previously incarcerated because of marijuana charges, had just only begun out in California. And it hadn't been something that had, become a national dialogue around how do we, honor the fact that this industry put a lot of people in prison. And now that it's coming on legal, how do we do that in a regulatory framework? And so I think since 2017, we've seen across the country, as states come online, most typically under adult use programs, that they're doing exactly that. They're creating some type of legal framework to allow priority licensing or, set-asides in some cases, or additional points on applications in other cases for those, not only those individuals who may have been arrested previously because of a marijuana conviction, but also the communities that bore the brunt of the war on drugs. So in some states, we've seen the use of zip codes as a means of qualifying for social equity as well, if you come from those communities that have been identified as, again, having that disproportionate impact. And so we've seen that across the country, but Florida was very unique in saying that at the time, again, we were only considering a handful of licenses, that it was going to take out of this handful of licenses that it was going to award, and award one specifically to a Black farmer. And so that's when we got into conversations of how do you identify someone who has been disadvantaged in some way to make sure that we're, again, in the spirit of the law, if you will, creating a way of honoring the war on drugs and the damage that it did. And so the Pigford case is a historic case that was tried back in the 90s. That was really and truly, it was a culmination of previous litigation that went nowhere. And then eventually, because of that previous litigation not going anywhere in the courts, a class action lawsuit was filed against the USDA, which was Pickford v. Glickman at the time, who was the secretary of the USDA at the time. And so this is, this was a national case. So there's Black farmers all across the country who, attached themselves to this particular case. And once settled, it broadened it out to others who have met that same threshold, but, who may not have been a part of the case initially. And so it took until the Obama administration to come in for the settlement payouts to finally begin to be awarded. And then there was a second pick for litigation as well to kind of expand the class a little bit more. And so, again, all of that to say, Florida used that particular national case as a way of identifying a disadvantaged Black farmer to be able to award this license to. Unfortunately, the way that it was written into the statute placed it right up underneath all of the other licenses that were to be awarded. And so the Florida grown case, unfortunately became, what was the holdup for that license being awarded. And so again, now that we've had the Supreme Court rule on that case, it's opening back up. But, I'd be remiss if I didn't say this. Again, as the board chair of a national organization that is fighting to, at every turn to make sure that we're creating the most, that we recognize that we have an opportunity as an industry to create the most diverse industry that exists in our country. Many other industries that have existed for decades and, hundreds of years, they have ceilings in place already for many different groups and so on. And so in the cannabis industry, we have an opportunity to, go a different route, to choose a different path. And so I am hoping that as we, get into these next 19 licenses, it's great that we're going to get ready to award this one. But, we're talking that'll be one, the 23rd license. So 1 out of 23. And then when we add the other 18, 1 out of 40. To me, we as a state can do much, much better. And I hope that we find ways to do that, in this go round.
Yeah, thanks, Eric. So just to kind of summarize, what it looks like we're going to have is 19 licenses, but there'll be kind of 2 separate tracks. There'll be 1 license, that's it, for a Pigford applicant, right? So they're probably going to do that under emergency rules. So that license will probably, or at least the application process will become available probably sooner for that 1 license. And then the other 18 licenses will probably go under the normal rulemaking process, and they'll be available a little bit later on. But, for those 18 licenses, certainly in this past application, they did require, a diversity plan. So there is something in there. Unfortunately, diversity plans are oftentimes just words. So, that doesn't necessarily mean that those other 18 are really going to truly be implementing something of significance with respect to diversity. But it's important to kind of keep that at top of mind. But I wanted to kick this next question to Jeff. One of the things that's been a big issue here in Florida is a lot of these licensees are kind of sitting on their license. So, it's vertically integrated. It allows you to open up all these facilities, which means it's expensive to become operational. So either 1, they're selling their license, or 2, they're kind of sitting on it, trying to raise the capital necessary. So I'm curious, how important in the application process from a scoring perspective do you think it will be for applicants to show that they have the financial ability to actually execute on their plan?
Yeah, thanks, Dustin. I think it'd be very important. If I could just kind of wind back, Eric, I want to thank you for that overview. I think that's very important and on the social equity. And as you know, I've had a lot of conversations with African-American farmers who are not Pigford applicants, right? There's a very small subset of people who feel like they're not involved in the process, obviously. So there's still some barriers there. And to your point, Justin, in that last application, as you pointed out, there's 100 points out of 1,150 points for a diversity plan. This is going to be a very competitive process. I know that's going to continue to be included. You can't afford to not get 100 points. You have 75 points on this on your application. So I think at least the people that I'm talking to, are taking it very seriously. And to your point, Eric, they're having, some people are having difficulty finding, and making part of an ownership team that, a variety of minorities, whether they be veterans, women, African Americans, brown, black, whatever. So I think it's going to be critical that they continue to do that. So there's that piece. As you know, and people in this watching this, almost all, except for one, of the 22 licenses have sold. Really, have been acquired, have merged, have sold for a variety of things. So over the last 2 years, we've seen all of that M&A transaction activity taking place. It's been, and as you can tell, the sale of those licenses has ranged from $42 million to $65 million in a combination. So that's an indication how robust this Florida market is today and will continue to be. I know there's been some frustration on the part of the legislature. There was a bill filed this year to require performance in the existing licensees and any licenses going forward. That bill didn't pass, but the message was very clear that the goal here is not to award a license to someone who says, I'm really committed, I'm going to do this for patients, and then as soon as they get the license, turn around and sell it to an out-of-state, MSO or, whatever. So I know that the regulators have been very clear about wanting to ensure that there are performance requirements. And I'll circle back to this. They cannot, a direct question that I've asked the regulator, are there any restrictions in selling any of these new licenses? By law, they cannot restrict that, right? However, you may have seen this, Dustin, there's a new rule that rolled out on the time frame for once an applicant gets a license, how soon they have to request cultivation authorization, which is important. Cultivation authorization, processing authorization, and dispensing authorization. In the last iteration, you had 180 days from the time you got your license to when you had to request the department to come in and say that you wanted their approval to start cultivating. It's now 60 days under this new rule. That's a remarkable change, right? So that either means you got to be really ready to go, you got to be committed, and you got to move, right? So that expedited time frame is challenging on one hand, for sure, but it's also a clear signal that the department wants. If you get a license, you got to move, and you got to start, you start producing product and meeting the needs of people. Anyway.
Hey Jeff, have they said what would be the recourse for an organization that did not meet that 60-day? Because that is, that's very aggressive, and I agree. It sends a very clear message.
Well, there's a cure period. Not to get into the weeds too much, but you have 60 days to request them to come out. Make sure that you are capable of cultivating. You don't have to cultivate; you get capable. If there are any corrections, they're gonna give you a corrective plan. You have 30 days to correct it. If you can't correct it, I think they're gonna pull your license.
Yeah, and I think this is important for, obviously, if you're doing an application, you're gonna want to demonstrate on that application that you're fully capable of meeting those requirements.
Right.
I mean, interrupt. Did you have anything additional on top of that, Jeff? Or
no, I think that's a pretty clear signal. I was really waiting for maybe somebody to challenge that, because on one hand, you either have to have a facility ready to go, or you've got to be strategic in phasing in, your business plan. But there's a lot of smart people trying to going to be applying. I think they'll figure this out. But it all tracks back to your application and scoring and everything else. So it's going to be interesting.
Yeah, and another thing, just to comment on the Pigford thing, there's the way they drafted this, it was drafted several years ago, and since then there's been a lot of different social equity language in other states that's come out, and some of it's clear and some of it's not so clear. But one of the things with the Pigford is there's a lot of ambiguity. They don't really specify what the ownership percentage needs to be for the Pigford applicant. Also, they basically say that you need to comply with the other requirements within the Florida statute, and there's certain requirements that seem to potentially be contrary to being a Pigford applicant. So, for example, when it talks about the Pigford applicant in the statute, it refers to kind of an individual, like an applicant is the Pigford person, right? But then there's another part of the statute that actually requires that an applicant have been doing business within the state of Florida for 5 years. And so kind of, you know, I know Erik and I, there's a few different teams we're talking to on the Pigford side, and kind of figuring out how to properly structure those deals and what's allowed and what's not allowed has become extremely confusing. So I don't know if Jeff or Erik, if you had any comments just relating to, you know, how that potentially will shape out.
Yeah, well, I mean, I think it's important, and it's something I know that from an organization standpoint, we're certainly paying attention to and watching, because I think what we've seen in other states as it pertains to social equity, and again, this is for all intensive purposes, Florida's social equity, you know, and I think we got a lot of work to do in that regard. But what we've seen in other states is how this is written in the rules in terms of what's allowed from an equity standpoint really and truly dictates how those deals are you know, developed. And we have seen that, you know, the rules have put have created circumstances and allowed for predatory partnerships to come about because of how that language is spelled out. So again, it is something that we definitely are watching and paying attention to, because you're right. You know, we're at one hand saying we want to identify a farmer who has been disadvantaged, and that means they've been disadvantaged in getting contracts awarded to them, you know, both at the state and federal level. They've been disadvantaged at getting funding, you know, from banks and, you know, at the local, state, and federal level. So the infrastructure that many of them have, and I can tell you, I've met with several, you know, Pigford farmers, and they aren't your well capitalized, well operationalized, you know, organizations. You know, they are your, you know, small mom and pop, you know, generational farmer. You know, they sell to their local, you know, market and very small scale distribution. And so, and that's not to say that there aren't some Pigfords who are, you know, in a much better place, but that is something, a challenge that I'm curious to see how it gets spelled out in the rules. But because again, any Pigford litigant is going to have to raise capital, even in the application phase. And that's going to present some challenges depending on how this is rolled out.
Jeff?
Yeah, no, I agree entirely. And to your point, Dustin, it is clearly unclear on the applicant and the entity, right? So, I mean, I think as regulator said, there are a lot of creative lawyers out there who will figure this out. Now, one of the other things, Erik, and you may comment on this, as you can tell, this Pigford applicant seems to be a, you know, much less competitive. I mean, let me put it that way in terms of numbers, because there aren't many out there left. I mean, these are elderly folks, as you know. You know, I've heard rumors of people soliciting Pigford farmers from other states, right, to come, creative lawyers again. And so that question came up in our conversations, and you know, I'm not sure how that plays out. I'm just, you know, so the question is, although it's not in the statute, do these Pigford farmers have to be from Florida or not? That's not clear in the statute either. So,
yeah.
So, but again, to your point, I think it's important that they roll this out first and get a clear understanding and focus on this particular subset. I think that's a debt that the state of Florida needs to pay. But it is an expensive proposition, as you know, and so they're going to have to put together some teams to help it out.
Yeah, and I think, you know, I see we're having a bunch of questions roll in. Some of them are about residency requirements. I think some of the questions that are rolling in were we're kind of addressing. So I'm going to wait to the end to kind of address. We've already gotten dozens of questions coming in on the chat and on the Q&A. But one of the things, you know, I wanted to discuss is for the past several years that I've been practicing in Florida, I've been getting dozens of calls a month about people that want to apply in Florida. And unfortunately, I have to keep just basically telling them, you know, there's no application process. And now it's turning into, you know, several dozen a week are calling. And now it's getting to the point where there are some steps you could be taking, right? I mean, you know, as we're discussing, there's some very serious requirements that are going to need to be met from a personnel perspective, real estate perspective, financing perspective. So I wanted to open it up to both Erik and Jeff, as far as if you're someone that wants to get a license here in Florida, you've been kind of waiting around. What could you be doing now to set yourself up for success? Of course, knowing that all the rules and everything haven't been ironed out. So don't get too far ahead of yourself, but what are some of the things you could be doing now?
Yeah, absolutely. You know, we know there is going to be some very basic things, right? Like we know there's going to be a vertically integrated system. So, you know, those very basic things like your cultivation facilities, your processing facilities, and, you know, retail locations, delivery operations. Those things are things that I think, you know, you can expect regardless of what rules change or anything. And certainly there may be some nuances that you need to adjust for when the application actually comes out. But the other thing I would also say is building your team, you know, identifying those individuals who are going to be on your application in a significant role, and identifying what they bring to the table, and really begin, you know, kind of assessing where your team is and where the gaps are, where the strengths are, and starting to pull all of that together. And then, of course, financial resources, making sure that those are in place.
Yeah, I agree with Erik. If those of you who are familiar with the kind of the application framework that the Department of Health at OMMU had rolled out under the previous rule, it's very specific in terms of every section, in terms of the questions they're asking potential applicants and the responses, right? Those are all really required by law. So I anticipate that all of those things, as Erik pointed out, in terms of, you know, what is your application going to look like and what team members do you need to respond to those effectively, those questions in each of those 14 sections are critical. I don't think they're going to change. There may be some additions to that, but those are kind of fundamental to the requirements of the law. And again, you know, we advise our clients, you know, you've got to find the strongest team possible. This is going to be very competitive. There's a lot of players interested in this, and you've got to look at how you're going to score on all these different sections, right? And again, diversity is important. You know, understanding Florida is important. Understanding the current industry is important. As you know, I don't know, Truly's got 86 dispensaries now. Finding dispensary locations is challenging. And that's one of the chat person says real estate is the key. It is for the dispensary and retail side of your business. Those are not easy to come by. Maybe a little easier, you know, post-COVID here with strip malls being a little bit more vacant. But there's a lot of pieces in this puzzle that have to be well understood, and you've got to, you know, put together a game plan that is you know, that is going to work well for your team and score well. I mean, that's as clear as I can be about that.
Yeah, I think there's a lot to be getting done from, I think it's a personnel and a real estate perspective. I've had a lot of people ask the questions, you know, how much real estate do we have to show that we have possession or control of on the application? And I just tell people it's going to be extremely competitive. Even in the 2015 applications, if you look at them, some of them were already identifying 4 to 5, dispensary locations and 2 to 3 cultivation facilities. And that was back in 2015. So I think here in 2021 or maybe even 2022, depending on when the applications come out, I think you're going to have to be prepared to show that you're ready to execute with significant amounts of real estate. So I think real estate is definitely going to be key. I know one of the people in the chat box said real estate is going to be key. Real estate is going to be very, very, very important. And how you structure that's going to be important as well. I mean, as we've seen, we did some licenses in Illinois, and they've been delayed out in Illinois. I think we applied in January 2020 for dispensary licenses, and we're in July 2021, and they're still caught up in lawsuits. And I'll tell you, I know a lot of groups that applied that entered into lease agreements thinking that those licenses would be issued within a few months. And now they're either stuck with this lease that they're continuing to pay, or the lease agreement is over and they're stuck with no real estate if they were to be awarded a license. So I think, working with attorneys and real estate people who are familiar with the industry, that know how to put those contingencies within those contracts or structure them as LOIs. There's a lot of different ways you could structure them, but please just keep in mind that in all likelihood, just like these rules will be challenged and you should plan for rules to be challenged, you should also plan for there to be further litigation if you apply. If you think that this is just going to be a nice little application process and 60 to 90 days, they're going to award, announce winners and everyone will go on their merry way, I'd be personally surprised. Almost every single state is embroiled in litigation with this industry. So I would definitely make that a part of your plan and your understanding as you roll out what you're doing. Next thing that I wanted to talk about is actually, we've been referencing the competitiveness here, and, to kind of put numbers to it from the Pigford perspective, what I'm kind of hearing is that there's, maybe around 10 people that could be applying for these Pigford licenses. Of course, could be a way, way bigger amount to the extent that what Jeff is saying is true, that out-of-state Pigford applicants could apply. And there's only one spot. So even for Pigford, it's not like if you have a Pigford applicant, it's a slam dunk. There's one spot. So even if there's just 10 applicants, that's still a 10% shot. And then, on the other 18, we saw out in Illinois, thousands of groups apply in Illinois for a very limited amount of spots. And I would think that Florida is probably even a more alluring state than Illinois is. So wanted to kind of, Jeff, Erik, open it up as far as, we're kind of talking in the abstract with respect to that this is going to be a competitive process. I wanted to see if you guys had any insight as to, what you expect actual numbers to be on applicants coming in.
No, I think you hit the nail on the head with the Pigford side. In the state, there are not that many of them that are there. And then we don't know how many are going to come from outside of the state, and if that is going to be something that is allowed. My hope, obviously, being a native Floridian, is that we continue to put our Florida farmers first. That to me has been something I fought for, even on the hemp side, and every aspect of this industry. So I hope that we take care of our Florida farmers first, because there are some who want to get involved, who meet that qualification, and I hope that that's taken into consideration. But in terms of the larger pot, I think it's going to be one of the most competitive application processes we've seen. I think the mere fact that the Florida market has produced multiple sales of licenses, in the 50 million average, range. Most people are going to, take a look at the cost of pulling together an application and say it's worth, it's worth throwing my name in the hat, And so I think we're going to see a tremendous amount of competition in that, in the general population, and we may see more competition in Pigford than we think.
I agree. I think the Pigford number is probably, I mean, what do I know? I mean, again, we all get calls and, talk to people. So again, but it will be a smaller subset without a doubt. Dustin, you get calls, we get calls, our medical marijuana business associations get some pretty, broad national profile. So, we've gotten a lot of calls. The key is, so let's just say there's 150 applications, let me just ballpark it, right? Or 200, right? You still have you got 18 licenses. It's, the odds, are still pretty good. We're not talking about 3, we're not talking about 5, we're talking about, but at the same time, if you, much like the last go around, the quality of the applications is, varies tremendously. This is going to be, as you know, de-identified, blind scored by an outside consultant, probably somebody like KPMG, who are, so the kind of limits the objective or subjectivity of it. So you really have to have a very strong, capable team. And I think there'll be a bell curve of quality. This isn't like any other state per se, because it's vertically integrated. Like you said, you got to have all the pieces. And just for example, logistics, inventory management is a big deal. How many people really know how to do that? So, I mean, I think there'll be, in the certainly in the triple digits, if not more. But I think that will play into the scoring process and the timeline it takes to get that scoring done as well. And so, again, I think highly competitive, very detailed, and you really got to know what you're doing. So I think if you had 150 applicants, I'd say 40, 50 would be really high quality.
Yep.
Right? So let's just say it's 50. Let's say it's 60. 1 out of 3 gets picked. Right?
Yeah. I think it's going to be very competitive. And, I get a lot of calls from people out of state that say, hey, we're operating a dispensary. And I have to remind them, well, this is a vertically integrated license. So you could be the most experienced dispensary in Colorado, California, and wherever else. But you're going to also have to put together the team for cultivation, processing, delivering, logistics, all those other things that Jeff mentioned that are extremely important. I've gotten a bunch of questions, so I'm going to start incorporating some of the questions I've been seeing into my own questions. So I know I've heard, I'm working with a group out in New York, and I know out in New York, I've at least heard rumblings that hemp farmers might potentially have some sort of advantage when applying for a license. One of the questions that I've seen, I don't know if that's going to be true in New York, but that's what I'm hearing. Is there any reason for anyone to believe that people who have been growing hemp here in the state of Florida would be in any sort of advantageous position when applying for a medical marijuana license?
My answer is no.
Yeah, I would have to agree with you on that one, Jeff.
Unless you have a facility, that's an indoor facility ready to go. This is not grown outdoors. I mean, it's maybe you want to start it in greenhouses, but I think it's a different, obviously different regulators, different agencies, skill sets, somewhat similar, but it's a different business.
And it's still fairly new here in Florida. I think had we been, a few more years down the road in terms of more, private businesses being a part of the hemp side, I think we would have seen more, infrastructure in place on that side that would have yielded well, to the MMTC side. But I think it's still too new to where it will impact. I mean, obviously, we'll see it on, folks' applications, of course, but whether it'll have a real impact, I doubt it.
Yeah, and one thing I'll say is that like these applications, it's all about telling a story, right? So if you're able to tell a good story where you have, multiple hemp cultivation facilities indoor that are growing high quality hemp, and you're able to provide pictures, on your application showing your, fully automated greenhouse, and you're already extracting hemp and you have extraction machinery, and you're able to show pictures of your lab, and you're able to tell kind of that story. Hey, we're already, because the main things they're looking at on these applications are experience, right? That's one of the key factors. And I think being able to demonstrate like, hey, we've been growing hemp, we've been processing hemp, we've been dispensing hemp, or whatever your hemp business is. I think really how you weave in your story is going to be important. I don't think just attaching your hemp license to the application isn't going to do much. I mean, I could get you a license, within
Right.
a few days. If that was that important, you're going to see a million people applying for hemp licenses. Just the license itself doesn't help. But I do think that there's an opportunity to tell a compelling story about your hemp operation and how that positions you well to be successful with medical marijuana. I'm just going to run through some of these questions we're getting. I want to keep this to under an hour. We're getting some really good questions. So one of the questions is there any role for pharmacies in Florida in dispensing now or in the future? Unfortunately, no. Once again, it's a fully vertically integrated license. You have to grow, process, dispense, and the dispensing is not out of anything that resembles a pharmacy. I'm hopeful that down in the future that could be potentially something, but right now that is not anything. Erik, Jeff, I don't know if you had anything to add on that.
I agree.
Is there any it says, is there any, I'm not sure what that question was referring to. So we've got a few questions on the residency issue. So right now, the way it stands, I get a lot of calls where people ask about the 30 years as a nursery requirement and stuff like that. That's done with, as far as the nursery requirement. But what they do still, the 30-year nursery requirement, but they do still have a requirement with respect to 5 years operating as an entity. So Jeff, I don't know if you want to touch on that. I mean, they don't really do anything as far as look through, as far as confirming that the owners of that entity are residents, but they do want an entity that has been operating for 5 years in the state of Florida. Jeff, I don't know. Erik, anything you want to add on that?
Well, I think that's the proxy for, residency is the 5-year business. But again, it doesn't require you to be a resident. That business, in fact, is a resident of some sort, right? As the applicant. So, but there's no, I mean, if you lived in New York and had a business here in Florida for 10 years, you would ostensibly qualify, as a threshold levels. I think the scoring, is going to, the story, Justin, to your point, the story you're going to tell about understanding Florida and the needs of the people and the patients, I guess is going to be critical. So.
And also I'll just note that there has been some litigation in several states about the residency requirement violating the dormant commerce clause. So it's a restraint on trade. So a lot of these states that actually do have residency requirements are starting to actually get rid of those residency requirements because of those court cases. And I'm not really sure. I haven't looked into those cases too much in detail. I'm wondering if whether even that 5-year operating as a business requirement could potentially violate the dormant commerce clause as well. So I'll just kind of throw it out there. I don't even want to begin to think about more litigation, but certainly that's this is why attorneys stay very busy in this industry. So got another question. When do you anticipate these new licenses will begin being processed, and how long do you think it will take to grant all 19? I don't think we know. I think we kind of ran through that a little bit. We think the Pigford one will come first. There'll be emergency rules. Hopefully applications open in the next few months, and then shortly thereafter, we're hopeful that the other 18. As far as awarding those licenses, I think that's a wild card because once again, there might be quite a bit of litigation that happens after that. So unfortunately, it could potentially be several years afterwards. I really hope not, but that's certainly possible. Let's see. And some of these questions I'm skipping just because we're not gonna be able to get to all of them. Some of them, so you're asking if this webinar will be available. I will make sure I make it available to everyone that signed up. I also think this is a good opportunity for me to let everyone know this is not the only session that I plan to do. I'm going to try, and certainly if Jeff and Erik are willing to join, we're going to continue throughout the process to put these on periodically to give updates. So if you guys are interested in continuing to stay in tune with what's happening, we'll be trying to have these probably not weekly, but maybe every other week, just to kind of keep people updated. So be sure to kind of be on the lookout for that stuff. And as far as the recording of this, we are recording it. So I will certainly email it out. If anyone wants a recording, you could just email it to me. My email is info@mrcannabislaw.com. You're willing to send that to me. I'm going to some more questions. I have a question. Will a disabled veteran-owned company meet the requirement as a minority-owned company? No, and actually there is no preference for even a minority-owned company. It's really just a Pigford applicant. So if you weren't a part of this Pigford case, there's really no advantage to you. Certainly, once again, the veteran thing is a good story. Jeff, I don't know if you've heard that allocation of any points or anything like that for veterans.
Well, it's also a part of in the diversity plan. Right. That's where it would be most appropriate, I guess, to kind of really play up any veterans on the team and what role they may play. But in terms of, I do think that will factor into that 100 points like Jeff talked about. Right. And I agree, you can't afford to miss any of those points. So I think the veteran piece is still important, but it didn't rise to a set-aside license like the Pigford did.
Yeah. Another question. I understand that diversity is important to the state. Are there specific points awarded for social equity applicants or minority-owned applicants? No, it's just this Pigford license, just one license for a Pigford applicant. With the 60-day window to cultivate, how would they justify that with electrical requirements that can take well over 60 days to get permitting? Jeff, any comments on that?
You're right. This was a little bit of a curveball in terms of that expedited time frame. So you really have to have a facility that's reasonably ready to go to start. I mean, you have to just show capacity, capability, and that's, you got to kind of think through that strategy of how you scale up your business. But yes.
Yeah, and I'm going to take a couple more questions. We'll run a little bit over, but we started a little late, so we'll just keep rolling. Can the regulators put in a lockout period for selling licenses? So, the department would be outside their authority, and they'd get sued very quickly if they tried to do that. So it would probably have to come from the legislator, and even the legislator might get sued if they tried to do that. They do have in some other states, like if you're a social equity applicant, they could put some, time requirements that you have to actually hold on to that license. But, I don't see anything. Jeff, Erik, anything to add on that?
No, I asked that question specifically and was told, no, there's no authority to do so, to prohibit.
Yeah, and kind of last question I'll take here is asking if we think Florida will ever go to horizontal. And I think this is kind of a good way to kind of end the session, is a discussion. Obviously, the Florida Supreme Court, they basically ruled that the vertical integration is fine. That doesn't mean, though, that we can't go back and eventually create a horizontal framework, especially if we pass recreational. So, Jeff, Erik, anything you want to talk about as far as the future for potentially a recreational market, as well as, potentially going horizontal within this market?
I think much like what we saw with the hemp market here in Florida, there's going to be a huge push against us creating another vertical model. So I do think we will get a horizontal model under adult use, but I don't think the medical side will go horizontal. If it does, it will be after rec is introduced, and I think the pressures on the market will then cause for that discussion to come back up. But I don't see it happening, prior to that.
Yeah, I agree. Two questions. One is what's the potential for rec adult use, As you know, both of the ballot initiative language were thrown out by the Supreme Court. They may be able to, work to get that re-engineered, and it's more and more difficult now to get signatures. So whether or not that makes the 22 ballot, I clearly expect it to be on the 24 presidential ballot timeframe. I think to Eric, to all your points, and Dustin, this is a very expensive proposition to get into this business. It's a $20+ million startup operation, right? And it freezes out a lot of people from participating. And as you know, there's a little bit of restriction on contracting and subcontracting. I think if and when rec comes, or these licenses get issued, market stabilizes a little bit. I think there'd be some real value in people, being able to wholesale or to have retail dispensaries. That's the biggest pain in the neck for some of these folks, is really running these retail dispensaries statewide. Let somebody else come in and do part of that for you under, I think that's where it kind of gets decoupled a little bit, allows for more people to participate. I think the legislature, and I know folks who care about social equity, would like to see that happen for sure. There was a bill filed this year by Senator Thurston, as you may know, that was designed to do that. Didn't pass. You can see where that's going.
To that point, Jeff, what is it that we have to do to get anything to move through our legislator besides this continual THC cap that they keep trying to push? Like how do we get anything else to move? And just your thoughts.
But the irony of all this is you've got the House, and I won't take too long. House of Representatives keeps becoming very, very conservative on these THC caps. It's a national trend, as you know. It's ridiculous. It doesn't pass. The Senate's much more supportive. The irony is you get 70+% of the people in Florida want this program, want adult use. Those people have got to be mobilized to tell folks, and there are ways of doing it. The ballot initiative is one, but if you can tell an elected official, listen, 70% of the people in your district do not want you, screwing this program up, right? And they want to do this. That's what they respond to. So you got to mobilize that advocacy, that grassroots, folks a little bit better than we haven't. That's another conversation.
Yeah,
I've thought about it a lot, but how do you get to those folks?
Yeah, and guys, I know I just dropped emails in the chat for everyone. I didn't get the chance to drop in Eric's, but Jeff, you want to just kind of quickly?
Yeah. Thanks, Dustin. Appreciate it, and happy to provide whatever information we can. For those of you, that's my email there. We do, the Medical Marijuana Business Association of Florida, we do have weekly and bi-weekly newsletters, bi-monthly newsletters that go out on kind of policy issues, what's happening in the state. So if you want to get in that list, doesn't cost anything. We have about 8,000 people who receive that newsletter. So happy to help with that. But again, thank you, Dustin. Thanks, Eric. Look forward to our next conversation.
Eric,
absolutely.
How can people get in touch with you?
Yeah, absolutely. I just dropped my email in the chat as well. erange@m4mmunited.org. The number 4 mmunited.org. Definitely, and you can check out our website, m4mmunited.org, and keep in touch with what we're doing. All things social equity, diversity, and inclusion, and just making sure that we're a part of doing what we can to really create the most diverse industry possible. So thank you again to both Dustin and Jeff, man. It's been an awesome conversation.
Yeah, thank you guys for being here, and thank you so much everyone for attending. Like I said, we'll be trying to put on more of these events as we get closer to this application. So thank you all, and we look forward to keeping in touch with everyone. Have a good one.
Thank you.
All right, guys.